hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we're going to talk about interesting topic. What are living legal documents versus dead legal documents?
You're going to have to do some explaining because how can I set up documents when I'm dead, Kirsten?
Oh, right. So we should probably establish that. You don't get any choice in being able to sign documents after you're dead.
No.
If you're dead, you're dead.
Although, you know what I have seen before?
What?
This is amazing. So I have seen before like people who have died or people who are like passed out or asleep. And you know how phones have fingerprint scanners?
Yes.
Someone put the phone like right under their finger so that they can unlock their phone.
Oh my word.
Access their stuff. Yeah.
Oh my goodness, that's hilarious.
It's bizarre.
You know, it actually makes me think about, so this weekend I was going through some old journals with my daughter Gabrielle, who's now 23 years old. And in this one part of the journal, I mentioned that my grandmother had passed away, and she passed away at a ripe old age, so it was, you know, kind of a beautiful thing. But I was crying about it, and the 4-year-old Gabrielle comes up to me and says, "Mom, why are you crying?" I said, "Well, my grandma died." She's like, "Oh." A little bit later in the day, my mom calls, and she picks up the phone, and she says, "Grandma, did you die?" and my mom goes, "Well, no, honey, I didn't die. I'm talking to you on the phone." And she goes, "Oh, I'm so glad, because I thought you died. I'm grateful you didn't die."
It's adorable.
Which is kind of funny, right?
Yeah. So living versus dead documents, the big difference is obviously you set all these documents up while you're alive. Can't set a whole lot of stuff up after you die. There's exceptions, of course. But the idea is you set all this stuff up while you're alive, and do you want it to govern your stuff while you're alive, or do you just want it to govern your stuff after you die? And the question is, well, I don't need it to govern while I'm alive. I'm alive. I can handle it. And the answer to that is, what if you can't handle your stuff?
And this is where we get into what's called elder law, because elder law is really sort of, we're going in two different directions in terms of the broad category of what are we doing to plan for our end of life. And some people decide to go towards estate planning, which is just thinking about documents that will go into effect after one passes away. Or we can go towards the more holistic elder law route, which takes a look at, are there reasons for having documents that I develop that actually do things now while I'm alive? And we believe we put that option in front of our clients, and we explain that a lot more. But today I think we should focus on what happens with documents that become alive now and then actually do things during our lifetime and afterwards.
Yeah, so these documents, you may have heard of them: powers of attorney documents, living trusts. The reason they're called living trusts is because you set them up while you're alive. And really what you're trying to combat against, the first battle with a living trust is, what if you become disabled? What if you become incapacitated? Same thing with these powers of attorney documents. That's the only reason you put them in place. If you truly cared about, I only care about after I die, I want my things to go wherever, then you don't need powers of attorney. You need a talking to by us, but you don't need powers of attorney documents. And so these living documents, they hold your stuff. And the big thing with estate planning and elder law is control. When do I have control? Even when I lose control, then who takes over control?
Because it would be better to be able to make that plan than to just leave it up to really the state.
Right.
Because the fine state of Wisconsin is happy to step in at any point in time when your documents don't control for something. So here's a great example. We just had a client who came in, and the wife had been disabled for many years. They had never gotten a power of attorney for healthcare for her. And then she had a catastrophic event decisions needed to be made. There was no one legally in charge to be able to make any decisions for her. Bless his heart, the client, who was the husband who tried to do this, actually filled out a power of attorney for healthcare document on her behalf and thought that he could sign on her behalf. That is not correct legally, and the hospital would not accept it. And so we had to do a guardianship action in order to then give him, the husband, the power to make healthcare decisions for the wife. And so we're in the process of doing that right now. Because that's an expensive and long process, he decided that he was going to do all of his estate planning documents for himself now while he has the capacity to do so.
Good.
He's avoiding the second crisis, which could potentially have happened. But that's the point. When you act in your living capacity to create living documents that will pick up for you when you have things happen where you're not able to make decisions, then those living documents are working really well. And that's what we want. We don't want documents to be manufactured, constructed in a way that will require the state of Wisconsin to be involved, because now you're talking about court hearings and all kinds of things like that.
Yeah, I totally agree. And it seems so odd to me that someone's going to go to a lawyer and say, okay, here's what I want. I want the government to get involved, but once the government gets involved with their rules, I just want to pick the players. It's like, well, why don't you pick a whole different game then?
Very good.
And when you get your estate planning done, especially with living documents, you pick the game, you pick the rules, and you pick the players. If you just get these dead documents that Kirsten mentioned at the beginning of this video, you only get to pick the players. The rules and the game is already chosen for you.
So what is the quintessential example of a dead document? Well,
a will.
It's a will. It's a last will and testament. And it basically does not go into effect until after you pass away. And you're exactly right. A will does give you the authority to decide who's going to be my personal representative and where are my assets going to go. Who am I choosing to inherit? But beyond that, the game is already set.
Right.
And so now you're walking onto a field that has all kinds of statutes and regulations and rules and requirements and things that will take a lot of time and a lot of money.
Right. And isn't it true, too, Kirsten, in Wisconsin, that for a formal probate, you must hire an attorney in order to do that?
For a formal probate, it is not required in Wisconsin.
Okay.
It is also not required in Wisconsin for an informal probate. But it's a little like going into, I don't know, a process that you just have no clue what to do. And there's all of this education and experience that has been developed by other people who know what to do. I guess it's a little like trying to do your own tooth work. You
exactly.
know, like if you went to could you go home and try to give yourself a root canal? I suppose
it's not illegal.
It's not illegal.
Yeah.
You don't have to have a dentist to do a root canal, but the knowledge and experience of the dentist makes it something that's typically not what a person would tinker with. They will go and get the root canal done by the dentist.
And the judge will only give you so much lenience for not knowing the rules.
Correct.
The judge expects, if you're going to play with the big kids, you need to know the rules of the big kids.
Right.
And so you're hamstringing yourself. Yeah, if there's any area of law in which I would always recommend getting an attorney, it's probate.
Yes.
Just because what can go wrong might end up costing you a ton of money.
That's exactly right. What can and probably will go wrong, it's just not worth the time and the effort and the frustration and the headache and just the not knowing.
Right.
Not knowing what advantages am I not getting because I don't know this law. And so that's what we need to think about. So that's a dead document. Obviously, documents that are not completed are dead on arrival as
Right.
well. So powers of attorney for healthcare and finances, if not completed and done properly and well. But then there's also ways in which a living document can be dead, have dead elements to them.
Sure.
Because if a power of attorney for healthcare or finances or a trust, if they're not written correctly, if they're written wrongly, if they are written incompletely, then you've got big gaping holes where it might result in more problems than literally if there was nothing at all.
Right. And in subsequent videos, when we talk about charities and all those other things, those are other reasons why living documents, not only can they help you manage your stuff if you ever become incapacitated, they may have some tax ramifications.
That's
positive
exactly right.
or negative. And so we want to make sure that depending on what our goals are, we determine, are living documents right for us, or are these dead documents right for us? I can imagine dead documents are not right for the vast majority of people.
No,
it's usually
really
for
aren't.
people that don't care.
Yes, that's exactly right. Well, thank you so much for joining us today. And hopefully this gave you a little bit more information about what kind of documents you might be wanting to think about. We have so much more to tell you. So give us a call, and we are happy to provide you with more education and knowledge about this all important area of the law. Thanks for joining us. See you next time.